Thank you very much. Pardon me. Good morning, everyone. You're very brave for doing this on a Friday and a Friday after Halloween. So I hope you got some candy ready to keep you full of energy this morning. Hopefully, my talk will keep you entertained as well. What we're here to talk about this morning is intellectual property, right? So trademarks, patents, trade secrets, and copyrights. So recognizing and protecting these assets that your company, whatever company you have, is probably going to create some of these, and how you can protect them and know the differences between them. As was said, we will do a Q&A at the end. So there's a chat function. If you have a question, write it down in the chat. We'll go through and we'll answer them. Just a couple things. I am a lawyer, but here I'm presenting as an educator. So any of the questions that I'm going to answer, I'm going to assume are hypothetical questions. And I'm not here to become your lawyer in this presentation. So this is just more of an educational seminar. And we're here to help you spot issues. And so we'll answer all the questions as best we can at the end. So with that, we will jump in. So again, this is just my disclaimer. I am a lawyer, but I'm here as a teacher, an educator. So I said we're here to talk about intellectual property. And so the first question usually is, well, what is that? So generally, there are three types of property in the world. So there's real property. So that would be your house. You own a house, the land it's on. That also extends to leases. So contracts involving real property are sometimes considered real property. So aside from real property, then you have personal property, and that's all your stuff. The interesting thing here is that sometimes personal property becomes real property. So when you sell a house, the washing machine may be included in the sale and is part of the real property. And that depends on the state you're in. So it's just, there's a little interplay. But now we're talking about the third group here, this intellectual property. And what is that? Well, that's it's a right. It's a creative right for something you created or you've developed. And what's really interesting, it's sometimes it's not a right to do something, but it's really a right to stop people from doing something. So it's like a negative right. So you'll see as we talk about things, sometimes you'll have rights, but it doesn't mean you get to do it. You stop people from doing it. And most of the time, it's stop people from copying you. The whole idea is to protect what you've developed in your business or on your own. And this is how it's done with intellectual property rights. So the core areas of IP that we're going to talk about today, there's four. We have five here because there's a little overlap between two of them. But first, we're going to talk about copyrights. And those are literary artistic works. I put the term here just so you get an idea how long the protection lasts. And it depends on who the author is. We'll talk about that in a sec. But if the author is a person, then a copyright will last for the life of that author plus 70 years. So if you pay attention in the news, occasionally you'll hear stories about someone who passed away about 70 years ago, and they'll talk about something coming off of copyright. Well, that means the time's now expired and certain things maybe fall into the public domain, meaning you can copy them. You'll see registration for copyright is not required, but there are reasons you may want to do that. The next we'll talk about trademarks. These are names, symbols, or other things that you use in your business to help create this association between that thing and your company in the minds of consumers. So what this is really protecting is this connection that consumers see something or hear something or maybe smell something and think of, hey, that company's really good. I see that. I know that's a good thing. And so if you develop that, the legal system wants to help you protect that. And as long as you're using that mark and protecting it, you can keep that mark protectable. If you register it, you have to renew it every 10 years. But again, registration isn't required for this one either. We'll talk about all this in a moment. Trade dress is very similar to trademarks. Trade dress is more of a physical thing, so like how a product looks or how a store looks, but it's the same thing. It's connecting this or protecting the association that consumers have with that thing and your company. So again, as long as you're using it, you can protect it and you don't have to register anything. We'll also talk about trade secrets. So what this is generally it's confidential information that your company has that gives you some sort of competitive advantage. Um, as long as you're keeping that secret or taking efforts to keep that secret, you can protect people from stealing that from you. And there's no registration here because it's a secret. You don't want to tell anyone about it or do anything unless you have to. And the last thing we'll talk about are patents. And patents generally protect technological innovations and inventions. And this is the one where registration is required. For a patent, you have no rights until the government has said you have rights. And these tend to last 20 years for utility patents. So for a patent that protects some functional thing, and 15 years for design patent. And design patent is how something looks. We'll talk about all these individually. We'll spend most of the time on the first few because those are the ones that most people encounter a lot more than they realize. And so those are the ones we really want to make sure you're aware of so that as you create them or encounter them in your businesses, you're doing the right things to protect them. So we're going to start with copyrights. You see I have my circle C here in a moment. We'll talk about that and whether you have to do that or what that means. But everybody should know that that circle C is a symbol for copyright. So copyrights, what is protected? Copyrights protect original works of authorship fixed in a tangible medium, okay? I've bolded 3 words here, original. So that means someone has to create it. It can't be taken from something else. Authorship. I used to skip over this one, but it's becoming more and more important with the use of AI. And there was recently a case where someone entered some prompts into AI about creating an image, and AI created an image, and then they applied for copyright on the image. Because AI was the one that made the image, there was no copyright existed in the image because there was no authorship, there was no person. I know the earlier case was the monkey selfie when someone gave a phone to a monkey and the monkey took the selfie, and whether or not that would be a copyright because it's a monkey. A monkey, I don't believe, is a person. So this authorship I used to skip over, but now it's becoming something we have to think about. And then finally, tangible medium. What does that mean? It just means it has to be out of your head and somewhere in the real world. So if I have an idea in my head or an image and I draw it on a piece of paper, perfect. That's a tangible medium. If I'm a programmer and I write code and it's stored in my computer, great. That's a tangible medium. If I'm a sculptor and I go to the beach and I build a sandcastle, well, the sand's going to wash away, but you know what? That's a tangible medium. It's out of my head and it's in the real world. And so really, those are the 3 things you need for copyright. And the bar is pretty low on what this is. So people don't realize it, but when they write things and create things and take pictures and they have copyrights in the things they've created. So what does this include? Well, the easy stuff. So literary works, books, but what about product descriptions or advertisements? If you ever watched the TV show Seinfeld, and Elaine works for a company and they have these descriptions of their products that are very story-esque, those are really unique. So those surely show some sort of original work of authorship. So literary works, even though they may not seem very exciting, still will have some protection. Musical works, so songs, the lyrics of a song independently of the music from the song, a specific recording of a song could have a copyright. So there are lots of times multiple copyrights involved in just one recording of a song. So if you're a musician out there creating music, I applaud you and know that you've got a lot of protection out there. Pictorial, graphical, sculptural work. So photographs, pictures, movies, drawings, designs, all these things are creations that have copyright protection because they're original, their authorship, and they're fixed in a tangible medium. As we get more and more into like business stuff, displays, prototypes, technical drawings, those are probably going to be included as protectable, but there's something very important about copyright. Copyright protects ideas. I'm sorry, not ideas, only the expression of the idea. So if I have an idea for a book versus I wrote the book, there's two different things there. So my idea could be a story about a Regency era family with 5 girls and the hijinks involved in finding suitors for these 5 girls, right? That's an idea for a book. I can't stop people from making stories like that, or because I haven't really written that story out. When I do write that story out, then I can stop people from copying that story. So there's a difference between idea and expression. And when it comes to sculptural things or things in the real world, we have to separate the usefulness of the article from the copyright and artistic features of the article. So here is my example for this one. We have a lamp, right? Now, a lamp is useful. It provides light. It's very helpful. But this lamp is very artistic too. It has some sculptural features down here. It has a pattern on the lampshade that either is water molecules or I think it's more of a Mickey Mouse head. So if I had a copyright on this lamp, I couldn't stop people from making other lamps. I could only stop people from making lamps that look like this. So there's an important distinction here between copyrights and patents, which we'll talk about at the end. And I did put this one here because you probably all recognize this person or this character. And the reason copyrights, if you remember, I said lasted so long, 70 years plus the life of the author. Well, this author involved in this guy was pretty prolific and helped ensure that his creations would be protected for a long time. So he was kind of the reason that copyrights last so long. So in your business, what are your sources of copyrightable material going to be? Well, photos, drawings, music, songs, books, if you're out there creating stuff, those things are likely going to have protections from copyrights. If you're out there creating logos for your business or for other people, there's copyright involved in creating those logos. As long as they're original and you're coming up with them, you'll be able to protect, or I should say someone will be able to protect that logo. Every business nowadays has a website, and there's a treasure trove of copyrights involved in the website, right? There's the words you write in the website. There's the source code behind the website, which is fixed in a tangible medium. The images on your website. Now I put a little note here from where. Remember, it's got to be original. So if I go on the web and I find a photo, take it and put it on my website, that doesn't work. I don't have copyrights in that photo. It's not an original photo. If I go out and take a photo and then put that on my website, well, you've got a copyright in that photo. So just remember, if I'm putting images on, you have to know where they're from. The other thing is this website itself. So if you look at my slides, you'll see I have this like overall feel, right? There's two kind of gray bars at the top. There's little blue square down here, white. They all have this overall impression. If people have a website that creates this overall impression, sometimes they're able to protect that. It's that as well. So there's really not necessarily the words, but it's the overall look and feel. There's some give and take here, and you have to kind of do a lot, but it is a thing that could be protected. So just be aware of that when you're out creating your website and looking at other people's websites. Let's say you create advertisements or flyers in your business. Again, you're putting things together and creating content. It's likely going to have some sort of copyright protection. Just remember, it's the stuff that's original. So if I put together a bunch of things that's from pre-existing sources, there's not going to be much copyright, if any, there. Now we get into other stuff, though. Employee materials and manuals. Those aren't really fun things out there. They're not exciting stories or fun pictures, but these are things you've taken the time to create. And so you're going to have some protection in those, and you're going to be able to stop people from copying those. And that's only fair, right? You've created these by spending time And so you should have some right to stop people from copying them without your permission or without paying you to copy them. So does that mean then anything written or typed could be protected by copyright? Maybe. A contract, I don't know, perhaps. A purchase order, a form like that, probably not, because these are getting into functional things. I do see, actually, I saw a judge do this on a court order. Say you can't post this court order or anything like that, or which that's probably not true. I've seen lawyers put that in their brief that you can't copy this brief. This is copyright. Again, that's probably not true. So there are some things that you know you'll get to. They have some functional nature or they're legal in nature, and there's no copyright there. But for the most part, almost anything you're going to write or type will be protectable. So what do you do with the copyright? Well, like I said, these are rights to stop. So they're rights to stop people from copying that work. And they're rights to stop people from making a derivative work. So it doesn't have to be an exact copy, right? So if I have a book and someone changes one word and makes a copy, well, that's still a copy. If they change 10 words in a book, that's still a copy. The test is whether it's substantially similar. So at some point, you have to change enough of the work to be different enough that it's not a copy. However, when you do that, you run into this derivative work. So a derivative work is a work that borrows from an original work and borrows enough that you think of the original work when you read the second work. So my favorite example of this is the movie Pride and Prejudice and Zombies. My wife's favorite book is Pride and Prejudice. So when I was dating her, I read the book so that she would talk to me and think I was smart. And it was a fine book. I enjoyed it very much. Well, a few years ago, a movie came out, Pride and Prejudice and Zombies. So it borrows from the book. It borrows the story of sisters in the Regency era trying to find suitors, and adds in this element of zombies. So it definitely changes the book. It's different from the book. But they borrowed enough so that you would think of the original work when you watch the movie. So that's a derivative work. There are artists that do this all the time who take a well-known photograph and add color and make it kind of punk rock or something like that. So those are derivative works. If you have a copyright, you can usually stop those people from doing that. And again, it doesn't have to be a copy. It's substantially similar. Now, one important aspect here is you have to show access to your work if someone's copying. Because in theory, if there are two people on opposite sides of the country that sit down and write the exact same song, they both get copyrights and neither is an infringement of the other. That is possible to happen. Is it likely? Probably not. But you'll probably read stories in the newspaper or hear them online or however you get your news about artists. Usually it's music getting sued for infringement of an earlier song. The biggest one I think most recently was it Pharrell and not Alan Thicke, Robin Thicke, and they had a song, and I think it was Marvin Gaye. His family sued because it sounded too much alike, and I think they lost, and they had to pay some money. The bigger earlier one was George Harrison and My Sweet Lord was the Chiffons, He's So Fine. So there was some infringement there. And what's interesting is that earlier one, it was found, well, he probably heard that on the radio because that song was playing so much that he inherently or just behind the scenes in his head when he's writing the song, he was thinking of that song. So showing access is important because if someone independently creates the same work, it's not an infringement. But let's say they copied. Let's say we could show access. What happens? What do you get? Ooh, severe penalties. So first off is an injunction. So you get a court order that says do something or don't do something, destroy these works or something like that. Money. So that's always good, is to get actual damages or infringers' profits. Something called statutory damages. So in the Copyright Act, that says if you don't prove damages, you can get $1,000 for damages without proving any automatically. That can be up or down. So that's helpful because proving damages is usually pretty hard. The last thing is attorney's fees you might be able to get. So it's called the American rule, but generally speaking, when you go to court, you have to pay your own attorneys. Outside the US, usually a loser has to pay some fee to the winner. But in the US, most of the time, everybody pays their own attorneys. So when a statute like the Copyright Act gives you the right to ask for your attorney's fees to be paid by the other side, that's usually a pretty good benefit to have. And then on the flip side, if you're looking at that, that's a bad thing. You don't want that to pay the other side's attorney's fees too. So having a copyright and being able to get that is a big benefit. So one important aspect of copyrights is trying to figure out who owns it, right? If you have employees, do the employees own it or do I own it? So typically copyrights are owned by the author. So the person who creates it is going to be the owner, the original owner. Now, these are property rights like any other property rights, like real or personal property. They can be transferred. So if you have a copyright, you can sell it to someone else or you could license it to someone else. But the original author is typically going to be the original owner of a copyright. There are two exceptions here, and they're kind of important. One is, the exception is works for hire, and that comes up in two ways. The first is employees. If you hire someone and their job is to create copyright stuff, then typically they're going to say, the courts are going to find that the company, the employer, is the owner. And this is important because if you remember, I said the life of the term of a copyright could either be 95 years or the life of the author plus 70. Well, if the author's a business, how do you figure that out? Well, if the author's a business, that's the 95 years. So you get 95 years from the publication. If the author was a business. If the author is a person, you're looking at life plus 70 years. So this is important to know who owns it, but to try and figure out how long is it going to last. So employers, if you have employees making stuff, it's probably going to be the company that owns it. But you'll see lesson here, just make sure it's in writing. The other work made for hire may not be an employee, but it's a commission work. So somebody hires someone for specifically to make something, like a logo. So usually the commissioning party is going to own that the person who pays to have them do something is going to own that the copyright and be the author, unless you have a writing that says otherwise. So again, my practice pointer here is negotiate in advance. And that's just a great business rule in general, is if you're paying someone money or hiring them to do something, you should just have a writing, something in writing at the time that says what's happening. You don't have to necessarily hire a lawyer. You can explain, I'm giving you money, I'm going to get a logo, and I'm going to own all the copyrights in the logo. That's probably all you need. But it's just something to think about as your business is developing these things, or if you're in the business of developing these things. This is an issue you should be focusing on and trying to address. So I said at the outset, for copyright registration is not required, right? It's an act of law. As soon as you create this material, behind the scenes, poof magic, you've created a copyright. It's there. You have these rights. So you don't actually have to file for a copyright registration, but there are benefits and actually one requirement you may have to do. If you want to sue someone in the US for copyright infringement, then you have to file for registration. So you could file after the fact. You don't have to file right away, but if you find someone copying and you need to sue them, you're going to have to at least file for the copyright. You can get rejected and they say, no, you don't get it. That's okay, but you have to at least file a lawsuit. The other benefit of filing for registration and doing relatively early is that you can get statutory damages and fees, so attorney's fees. So I said these are two good things. If you don't file right away, you won't be able to claim these. So if you wait 10 years to file a copyright registration, unfortunately, you won't be able to obtain these fees. So there are benefits to filing a registration early. And copyright notice. So if I've created this stuff, do I have to tell everyone there's a copyright? No. There is no requirement that you put the Circle C on the stuff you think is a copyright. However, if you want to slow the slow copying that exists these days, you might want to put it on there. And typically you do it with a Circle C, the year of first publication, and the owner, so that if someone wants to actually contact you to use it, they know how to do that. But you don't have to do it. It is very important to understand the flip of this. If you don't see a Circle C on something, that does not necessarily mean you can freely copy the work, right? Now that you all know that it's not required, that means all those photos I put on Facebook that don't have the Circle C doesn't mean people can copy those and take those and use those for whatever they want, just because it's out there. I know it's hard to in this day and age of I put a photo on Twitter and everybody likes it and takes it and uses it. But just because it's there and just because someone put it there doesn't mean that's necessarily permission for someone to take it. In fact, they could have got that from somewhere else and they didn't have rights to do that. So, it's the wild, wild west on our phones and on this. But you should know that just because you don't see that C, it doesn't mean anybody can do whatever they want with that picture. So if you're going to register, what do you do? How do you do it? So it's handled by the Copyright Office, which is part of the Library of Congress. This is, I'm pretty sure, still their website. I checked last night or the other night. This should still work. You fill out a form. It's pretty straightforward. They just ask some basic information. The fee that you have to pay depends on how you do it, whether you do online or mail in. Online is usually always cheaper. But however what you're registering dictates the fee, and mail in or submit the form, and in about 8 to 14 months, which for the federal government is relatively fast, you should have a decision, which usually is an approval, which is the second half of the form you submitted filled out by the Copyright Office. I had one register in 2 months though, so it can go really fast sometimes. Sometimes they say no, and you can fight with them and say, no, I'm entitled to copyright. Here's why. But they don't always say yes. So you might have to fight a little. But in any event, it is a fairly straightforward procedure. And compared to the other IP protections that require registration or that involve registration, not require, it is pretty easy and straightforward. So now we're going to transition from copyrights to trademarks. And we'll talk about trade dress a little together and a little separately just to get some examples. But trademarks. So here we have our Circle R, which we are only using if we have a registration on our mark. So we shouldn't be using that without a registration. If you don't have a registration, you can use the little TM for trademark. Or if you're providing services, you use SM for service mark. So these symbols, if you have a mark and you want to start using them, you can. You don't have to again, but only use this one when you have a registration. So what are trademarks? So these are words, symbols, logos, lots of different things you'll see that businesses use to identify their goods or services and distinguish those from the goods of others. Service marks are just marks, but they apply for the source of services. So if I'm a lawyer and I provide services, not goods, I could have service marks, not trademarks. So if you recall, the IP involved here is protecting this kind of connection between the mark and the consumer thinking, I know the source of that good with the mark or the service with that mark. And that's a quality good. So in order to do that, the rule is the marks need to be distinctive. So they have to be able to operate this way, because if they're not distinctive, then that can't really make that connection. They won't be able to create that connection to consumers. And so there won't be much protection. So we're going to talk about kind of this level of protection with some word marks, but then you'll see there's other things besides words that you can use. So for word marks, this level of distinction is important, because the words maybe describe what you have or maybe they don't. And how it relates to your goods or services is going to depend on whether or not you have trademark rights and kind of how strong they might be. So I have on my scale here, and we're gonna start at the bottom where there's gonna be no marks, no trademark rights. We'll work our way up where there's some rights, and as we get higher and higher, you have kind of more rights. So we'll start here with the generic mark. So what's that? Well, that's a mark that tells you what it is. So if I want to sell shoes and I want my mark to be shoes, yeah, that's not going to happen. So will I have any protection? No, because someone's going to see shoes on shoes and that's not going to work. So, so generic marks are not protectable. So we got to move up. So we go to descriptive, and a lot of people like descriptive marks because it's related to what they're selling. So shoe land for a shoe store. Is the shoe store really a land of shoes? Well, I don't know. It's not generic because that's not what it is, but it kind of describes what it is. So it could describe a quality. So yesterday was Halloween. So if I have candy and I wanted to call my candy sweet or sweets, well, that's kind of describing a quality of candy. So that's not very high on the list. It's probably not generic, it's probably descriptive. So can I protect a descriptive mark? Maybe. It's my favorite lawyer answer. Maybe. It depends. It's only protected with secondary meaning, or you show this acquired distinctiveness. So that's me coming in and proving, hey, I've been using sweets for candy for 150 years. Everybody knows that you see sweets on this type of candy, that's one source, that's me. This is difficult to do. And so, people like descriptive marks, so they need to know that, well, you can protect it, but it's going to be hard. And the scope of protection you're going to get is going to be pretty limited. One important thing to note here, if you are using a last name, a surname, that's primarily merely a surname. So I don't know, Smith, they're going to treat that mark that as the same as descriptive. So you're going to have to show some distinctiveness. If you have a very unique surname, then that shouldn't be what happened. That shouldn't happen. So it only happens for those names that are usually just names, like mine. All right, so we want more protection. We're not happy with the descriptive level of protection. We want more. So we go to suggestive. So suggestive is a mark that kind of makes people think about the goods, but it's not descriptive or generic. So if I have a shoe store and I call it Laces Up, right? If you hear Laces Up, your mind might jump to shoes. Okay, well, that is suggesting to you that, hey, that place probably sells shoes. Is this protectable? Yes, absolutely. I don't have to show secondary meaning, acquired distinctiveness. These marks we're going to talk about now inherently are distinct. So suggestive marks are great, and I'm going to have a little more protection than these descriptive marks. But let's say I want a little more. I want to get higher up. I'm really worried. Well, then you can pick an arbitrary mark. So if I have a shoe store and I call it Pickles, there's no, as far as I know, Pickles has nothing to do with shoes. I could be wrong. I'm older and not cool, as my kids say, anymore. So, but as far as I know, Pickles have nothing to do with shoes. So it's arbitrary. It's a word that really has no connection. Protectable, yes. I don't have to show secondary meaning. And this is good because, what are the odds someone else picks an arbitrary word like that and does something similar? Low, right? So you're going to have more protection here. But let's say I want even more protection. Well, then I'm going to do a fanciful word. I'm going to use a makeup word. I'm going to create a word that no one's done before and use that. So I have jub, which is someone else, Lewis Carroll made up. So it's not really, I didn't make this up, someone did. But it was when he wrote the Jabberwocky, jub was a made up word. He made it up. I think half that poem is made up words. So if I create a fanciful word for my goods or services, protectable, absolutely. And the scope of protection is bigger because, again, what are the odds someone comes up with the same made up word for similar goods? That doesn't smell right. So the higher you go up the scale, the more protection you're gonna have. So as you're out there creating word marks for your goods and services, remember this scale and think about it and go, can I do anything at the top? Because that's a little better. One thing to know about word marks, they can be plain or stylized or both. So when you have a word mark, it could be, just plain old words, whatever type font you want, whatever size, or you could stylize it and have a specific capitalized. It doesn't matter. You can have both. It can have colors, not colors, again, or both. You can have one with color. You use the marks differently so that you kind of have more protection. So I have a couple examples we could take a look at here. So here we have a stylized mark, Wilson. I love this one because if you drive into Kennedy, go to the airport, you probably drive past this and maybe see the W. But here, Wilson, well, that's kind of a last name, right? So if you look closely, I don't know if you can see that well, but you see this section 2F, SEC 2F here. What this means is they had to show acquired distinctiveness. They had to show secondary meaning. So without looking this up, my instinct tells me that someone at the trademark office said, this is somebody's last name, usually. Do you have any evidence that you've been using this for a while? And the Wilson Sporting Goods Company was probably able to come in and show that they've been using this for quite some time. People know this name and specifically this version of this name, and think of them. This is my other favorite word mark out here. So it's 2 all beef patties, special sauce, lettuce, cheese, pickles, onions on a sesame seed bun. Okay, so technically that's not a word that exists. They made that up, but okay, that's a word mark. And is that generic? I mean, that's kind of, but right. So this is McDonald's. And they had to, again, file section 2F. So they had to come in and say, oh, we've been using this phrase mark for a while to describe hamburgers. So they were able to get this protected. I don't know if they still use this, but anyways, I kind of like that one. But those are word marks. That's what, whether it's stylized or plain, that's kind of what a registration looks like for a word mark. And you'll see here they have goods and services. So that's kind of the other side, is you are related to what you're doing. So you can't pick a mark and then say, I'm going to protect this mark for computers unless I'm using it with computers. So beyond word marks, there are lots of other things that people use as trademarks. So they use symbols. So here's a symbol that's kind of common. This symbol has a color claim in it. So the colors and the way this is depicted is part of the symbol. And that's probably because they needed that to make it distinctive from what was out there already. So if you're like me and you have children and they have devices from the Apple company, you probably click on this a lot to see where those devices and your children are. But this is a symbol they have for downloadable and recordable computer software for geographic location. It's good. The next one, a logo. This is a great logo. One, because everybody from Chicago knows this logo, but two, the IP dispute behind this logo is fascinating because I believe it's based on a picture someone took, then they drew the image, and then someone took the image, and there's all this stuff going on behind the scenes, right? But someone came up with this logo. Nike uses it for, amongst other things, basketballs. So if you create a logo, you can use it for your trademark. There are also, we'll call them non-traditional trademarks that exist. So you have the sound. NBC has the chimes, Universal Pictures. I always think of the little minions out there humming along or singing at the beginning of some of those movies. So sounds can be trademarks. The color, so, and it's apparently called Robin's Egg Blue for Tiffany, the jewelry store, their packaging. So associated with jewelry, this color blue is protected. Fragrance, so smell. These Corel dolls all smell like vanilla, which I can attest to, as my daughter had one. But only one company is gonna be able to sell dolls that smell like vanilla. Product packaging, design of a business, these fabric designs, these are all trade dress we'll talk about in a sec. So they're a little subset of trademarks, but you know how a package looks, so Coke bottle, how a restaurant looks, and usually it requires a couple restaurants, but McDonald's, you think about how they all look very similar. And when they upgrade them, they all get upgraded to look similar. Fabric designs and patterns, so that Burberry has patterns. It gets into colors. So can colors be functional though? there's a kind of a fight and it kind of a pendulum swinging about whether green can be functional or is functional with respect to farming equipment. So some courts say it is, some courts say it isn't. So one thing to think of here when we get to these non-traditional trademarks is one, it has to be distinctive, and two, it can't have a functional feature. So if you're in a business that uses a color that's a high vis color, and it's in a business that there's danger involved, you use this high vis color to be functional. Well, you may not be able to claim that that color is a trademark because there's a function for that color. So when you get to this non-traditional trademarks, you have to kind of think about that a bit. And remember, it has to be distinctive. So that's why. So if it's functional, well, that's like the genericness. It can't really be distinctive. So where are you going to create these trademarks in your business? What are the sources? Well, your company name, as long as you're using it with goods and services. So if I create Smith's Shoe Shop and don't really do anything with it, don't really use it with my goods and services, it's just maybe a sign on the wall, that's probably not enough. It's got to be on stuff. It's got to be on my packages. It's got to be, on mailers and advertisements for my services. So you have to use it with goods and services. So the company name might be, but certainly product names and lines where you put those goods and names on those goods. Those are great. That's perfect. That's probably where it's going to be. Service level. So if you provide services, I'm going to use the example. It's pretty poor, but gold, silver, bronze level services or something like that. You probably can't do that because it's pretty generic to that type of ranking. But I don't know, maybe if you did it backwards or something like that. But if you're offering different levels of service and come up with the names and use those names with the service levels, that would be protected. If you create a logo, yeah, those are great. That's going to be something that would be trademark. But if you create that, well, that's also an original work of authorship that's fixed in a tangible medium. Guess what? Now we have copyrights too. So I said before, these might interplay. So if you create a logo, you probably also created copyrights. And that's important because they're two different IP rights and they are protected differently. And, before I said copyrights, you have to have access. Well, logos, trademark infringement, you don't, right? You don't have to know about someone else's mark. If someone just has rights and goes, hey, actually I have that mark. You don't have to have knowledge about that. So it's good to have interplay here because there are different things involved. So who owns a trademark? We'll talk about the US because we're all in the US here, but I will mention outside the US as well because it's a little different. But in the US, it's usually the first person to use the mark and use it in commerce, but it could be the register, and I'll talk about that in a sec. In the US, rights are acquired and maintained through use. So I pick a mark, I start using it. Once I start using it, I've created rights. Just like the copyright, it's kind of like a magic poof of law. I've created rights. As long as I keep using that, I've got those rights. You don't have to register to get those rights, but it enhances protections. We'll see that. The US does allow you to apply for a mark based on your good faith intent to use. So if I have an idea for a mark, I've done all my market research and I go, I really like Smith Sweets for candy, but I need to get a loan. I need to do all these things. You can apply for that mark and you'll have that date, even though you haven't used it yet, that'll be considered almost your first use date if you ever get into a dispute down the road. So if you've got a mark ready to go, but it's a while before you're going to use it, you may want to file an intent to use registration, because if I don't file and I have an idea to use it, and then my neighbor decides to start selling the day after or the day before me, my neighbor's going to win because they were the first to use it. So this is important. So in the US, it's first to use or register. It depends on when you filed, if you filed an intent to use. If you're going to use the TM, it's for unregistered. Only use the R if it's registered. I will say most US states have a state trademark registration system. I very, very rarely use that or talk to clients about using that, but there are reasons you may want to do that. But that it's more of a registration. They'll just accept your money and give you a form for a while. Um, that's the US. Outside the US, it's usually going to be first to file. So if someone's the first to file for a trademark application, they're going to win, even if someone else was using it first. So just know outside the US, there are different rules and they could have the opposite result. What's really important about trademarks is to know that when you have them, it's your affirmative legal duty to police them, right? This is not an option. Remember, the trademark, you have rights in that trademark because somebody is connecting that. The consumers are connecting that mark with your goods, your company. And if you're not protecting that yourself, well, the court system, the courts, the law is not going to help you either. So if you're not out there, you find out someone using it, you're not taking steps to stop them, you could run into problems. What type of problems? Well, marks can become generic if not policed. So remember I said generic marks aren't protectable. If I come up with a word for something, I don't know, let's say escalator for moving staircase, and I don't stop people who are using that mark and they start using it generically to say, oh, look at that escalator, look at that escalator. Well, what's going to happen is what did happen. Escalator, it became generic. So escalator was a trademark. Company didn't protect it. And now escalator is literally the thing that it describes, right? It's the escalator. Trampoline is the same thing. Trampoline was a trademark. They didn't protect it. And now trampoline is literally that thing. So you have to do that to protect it. I have aspirin here because, again, this is where the US and outside the US may have different results. So in the US, company didn't take protection, they didn't take steps to protect it, so they lost rights. So aspirin is generic for acetaminophen in the US. You can use aspirin to describe acetaminophen. Outside the US, it is still a trademark. So if you go to a pharmacy outside the US and you see aspirin, that's from a company. No one else is going to say aspirin. They're going to say acetaminophen. So again, you have to do this. How do you do this? Well, you can just do internet searches, right? And see if people are using it. Everything's on the internet now, apparently. So you can do that and see if somebody's using something similar. And if they do, write them a letter, say, hey, I don't know if you knew this. I'm Pat. I've been using this mark forever. Can you please stop? Most people will. Some people won't. You have to escalate your response, but you have to do something. If you have a lot of marks, you can subscribe to a watch service. These are companies that will check trademark offices around the world and tell you and say, hey, Pat, someone's registering a similar mark, and do you want to stop them? And so that's helpful, especially if you have a lot of marks. A lot of companies do that when their trademark portfolio is very large. How do you properly use your trademark? Well, one, try and distinguish the mark from surrounding text. So when you write something or advertisement, right, make it different. And we've all seen this, right? People bold it. So if I'm doing cough drops, Smith's cough drops, Smith's is bolded and it's supposed to be italicized, but it's a little different than the surrounding text. Always use your mark followed by the noun if it's goods. So I have UGG boots or Kleenex tissues. Right? These aren't, look at all those Uggs. Look at those UGG brand boots. Can I have a Kleenex? No, can I have a Kleenex branded tissue? These companies spend a lot of time and money to make sure people don't genericize their marks. So this is something you should do with your marks as well. So don't use plural. This is the same thing. Don't use it as a noun, right? If you have, cups for cups, don't do that. Don't use it as a verb. Right? So you don't Xerox a document, you copy a document at a Xerox machine. Don't Google something. You perform an internet search with the Google search engine. These are issues that real companies have, but it's something that you as a business owner should make sure you're aware of with your marks, because if it's the mark owner that's doing this, that can cut against you and it can hurt you. So we want to try and minimize that. You have to use it in commerce again, and it's got to be with the goods and services. So you slap a label on, you put a sticker on the box you sell. Stickers are great, labels are great. You just got to make sure it's using with the goods and services. And it doesn't necessarily have to be your company. It can be through a related company, like a licensee, something like that. So if you do that, you just got to be able to check on their goods and services. You can't just give them the rights to use it and not check on their goods and services. Make sure they're meeting your high standards of quality. So I'm going to briefly talk about this registration versus not registration. Because again, copyrights, you do not, or trademarks or copyrights, you don't have to file for registration. Again, when I start using it, I'm going to create rights. But typically that's going to be bounded by where I use it. And it has to be on the market. So if I've got plans to use it and someone uses it before I begin my first use, then I'm going to lose it. Or they're going to beat me. So you can still get rights, but there are dangers involved and limits. If you file for a registration, what's going to be valid in the whole country? So if I'm in the US and I only really am working in Chicago right now, but I have a registration, well, then I'm going to get the whole US. I'm going to protection in Alaska and Hawaii, even though I don't have sales there yet. I could file that intent to use application. So if I need time to expand, I have that time. So that's really important because it does give you that time to get a loan and get out there and kind of develop your brand before actual use, which is when rights would be created. And one last thing, if you have a mark and people are shipping in counterfeit goods and you have a registration, you can actually give that registration to the Customs and Border Protection and tell them, and they'll look for stuff and seize stuff for you. So that's a benefit that some companies really like, because that's very easy to stop things coming in the US that they don't want to come in. So if you're interested in registration, how do you do that? Well, like I said, federal registration is probably the most relevant, although there are some state ones. Here's the USPTO website, which is the US Patent and Trademark Office. And then the trademark is one half of that. Again, you file online or in paper. Online is cheaper. You pay a fee per class. So they've divided every single class of goods and services into some number of classes. I think it's 45. Pick which ones are relevant to what you're doing, and you have to pay per the number of classes. So if you have like 25 classes, this gets expensive. So maybe you pick your most important ones. You file your application. What happens? Well, in about 6 months, you'll get something from the Patent and Trademark Office. They might say, hey, there's some issues. Let's figure these out. But 6 months is pretty fast. And you can do a search to see if people have registered trademarks. And here's their trademark search database. You can go there and enter some marks to see if someone's using it, and then look at the goods they're using it on to see if it's close to yours, not close to yours, to make sure you don't run into any issues. Because again, you don't have to know about someone else's trademark to be infringing. So knowledge is not a requirement here. We'll briefly touch on trade dress here, which is just a subset of trademarks. But trade dress, it's got to be distinct or distinctive, so it has to create that impression. And it's the overall impression of a non-functional design, packaging, configuration. So the look of a store, product. So here's a package for a product, right? The product is actually the liquid inside. But here, this is a case where I think the vitamin water company sued Asante. I think that was this one. But anyways, they talk about the different elements. So what was it? Well, they're both bell-shaped plastic bottles, vertical presentation of words, two-tone look where one of the colors matches the color of the liquid, a clear cap. Ultimately what they said was they're borrowing a bunch of stuff that makes it look like it's ours, and someone is going to be confused. And I think they actually won this case. But it was this product, because it's the packaging for the product, right? It's not the color of the goods, it's the product packaging. Here's another one. And it's maybe hard to see. I have to zoom in, but the dotted lines don't form the mark. It's actually just this little navel here, and then there's no function to it, but it's just a navel in these wine bottles that this company's decided to use, and they're the ones that use it, and it makes people think of them. So that's another product packaging. Here's a product design, right? That we're probably all familiar with. And actually, I was looking at this the other night at hockey practice for one of my kids, and I pulled out my current phone, and I think my current phone still kind of looks like this. So I'm guessing this this registration would probably protect current phones. But anyways, this is the Apple. I think this is the first iPhone, maybe the second. And they describe their configuration here of what it is. I will say they had to show, I believe they had to show a lot of acquired distinctiveness here. And the way they did that is by showing stories of people waiting for days in line outside Apple stores because they had to have this phone. They wanted to have this phone. And they showed the sales of this phone on the first day, which was substantial. So they were able to come in and show, look, this phone looking like this, people see that and they think of us. And here's why. And so they were able to show that and they got a registration for that. So again, the registration, it's similar to trademarks. So there's no functional aspect. So we'll jump back real quick. So they have this. That doesn't mean they can stop people from making phones. That only means they can stop people from making a phone that looks like this. So if I create a phone that functions the exact same way as the iPhone or this version of the iPhone, they cannot use this trade dress registration to stop me. As long as my phone doesn't look like this, I can do it. So there's no protection of the functional aspects. It's not what the phone does, it's what it looks like. And like I said, you got to show distinctiveness, so it's a lot of evidence. And the protection's similar to trademarks. So I stopped confusingly similar things, and I can stop those. We're gonna shift now to trade secrets, which will be pretty short because there's not a lot to talk about here. But trade secrets, as you recall, or may recall, are the ones where there's no registration. So what are they? Well, they're anything really, a formula, pattern, design, method, process, whatever, that you use in your business, which provides you a competitive advantage over your other companies that don't know about it. So something that's secret that gives you some advantage over your competitors. We'll give some examples in a minute. The really only requirements are that it's secret and you got an advantage. You have to also be taking steps to keep it secret. What steps do you have to do? Well, it depends, but not much. You just have to do something so that you can say, I was taking steps to try and keep it secret. So trade secrets, there's no process for registration, right? I don't send in a bunch of trade secrets to the government. That would be interesting. What happens is they get proven in a lawsuit. So an employee leaves, they took a bunch of stuff. You sue the employee and say, hey, you took all my trade secrets. And they say, well, what were they? And you say, well, you took the customer list and you took the formula for my salsa and you took this and you took that. That's how it happens. So there's no registration. This is more of an after the fact thing. But you want to take some steps before that happens so you have a better case if that happens. Because once it's no longer a secret, you might lose protection and you probably will. So you want to recognize these things before they become an issue. So what are your potential trade secrets? Well, there are lots. Marketing plans, strategies, business plans. So when you come up with a plan and go get your loan and have here's what we're going to do, and we're going to expand slowly at this pace with this first store, but then 2 stores later on. Well, that's, it's helping you get a loan. That's something that's not known. So that's probably a good thing to do and protect. Customer and supplier list. Now, a lot of times people like to put their customers on their website. That kind of cuts against this. So if you're going to do that, make sure you have something more. If you ever watched the TV show The Office, and Michael Scott was the boss, and he had a Rolodex with all his customers on it, and he had notes on the back about the customers. Now, he had a weird way of it was actually the opposite of what his notes were, something like that, which is even better trade secret. But he had all these notes. Well, that was the trade secret. It wasn't the list of companies that bought the paper from him. It was all that stuff he compiled about those customers. So just having a list of customers, that may not be enough. But knowing what they bought, who the contacts are, what type of terms they like, that information, that can be protected. That could be really helpful for a business. Supplier list, same thing. Maybe not just the list, but facts about the suppliers. Business plans, again, just talked about that. Employee compensation. I always put this one up there because what if that you pay a little more than the company next door? and that gets you employees and helps you retain employees. Well, that could be a trade secret because you don't want people to know that. So you may want your employees to kind of keep that secret. Um, Non-public recipes, designs, formulas that can't be reverse engineered. So if I make a product and sell it and someone can take that product apart and rebuild it, well, that's not a trade secret because they could reverse engineer it. Not everything that's sold can be reverse engineered, right? So the Coke formula is still a trade secret. No one has been able to copy Coke exactly. So just because something's sold and could be reverse engineered doesn't mean actually people are able to do that to get to the secret stuff. Maybe it's not the recipe you have, but how you have, how you make it. Instead of adding the tomatoes first to your salsa, you add the jalapenos first or something. I don't know. My wife loves to make salsa, and I love to be her test dummy. So I'm sure she has some secret ways to make it because it's delicious. So if the way she makes it, the order of things she does is what makes it especially spicy, maybe that's her trade secret. She certainly doesn't tell me, which is probably the smart thing to do. But these are all things that you can protect as a trade secret, and you might want to take some steps to do so. So what do? Well, you got to keep it secret. So how do you do that? Well, you mark it confidential. Get the stamp or use the electronic stamp. Access to employees or contractors who need to know. That's like a spy movie, but that's a way you could keep it secret. If you have a contract with your employees or with someone you're hiring, a contractor, and they have to learn, they need to know it, you have them make sure they agree to keep it secret. So a lot of times in contracts, that's a common clause. So you may want to include that. If it's on a computer, maybe at a minimum, your computer has a password. Maybe the document has a password. That these are bare minimum steps that you should be taking for anything you want to say is a secret. So lock your doors. Your business doors should lock so that people can't come in and just get the stuff. Limit control copies. So sometimes on sharing PDFs or documents like that, you can turn off editing and printing and on those functionalities. You may want to do that. Employee policy on USB drives and copying. A thumb drive in, cut and paste, and thumb drive out takes not a lot of time. So if you have a policy on that, whether or not people follow your policy is a different thing, but have something written, right? That's a very simple thing to do. This will help you in the future because if you're not doing something to keep it secret, a court, the law may not help you protect it. But if you're doing something, someone got around that and they're taking it, you can help protect this. All right, now we're gonna jump to our last one, which is patents. And like I said at the beginning, patents are the ones that require registration. So there are no rights in a patent rights until the government has said you have patent rights. So, and what are those rights? Well, it's the right to stop someone for a small amount of time, 20 years, from making, using, selling, offering for sale, or importing the invention. So this is a monopoly, like all of these, they're monopolies. And it's a right to stop someone. It's not the right to make it. We'll talk about that briefly, but it's the right to stop people. The three basic things for an invention, whether you can get it or not, it's got to be useful, it's got to be new, and it can't be something that's an obvious modification of something existing. So useful, most anything's useful. That's usually not an issue. New, it can't be out there already. So the exact thing you came up with can't already exist. But that also means it can't be obvious. So if I just change the color of something that exists, well, that's an obvious change. Unless maybe I could show some amazing result from that. But usually these changes that someone will look at and go, well, yeah, I would make that change. That's pretty easy. That's not enough. So it has to be a non-obvious change. If you come up with something, you can conduct a search. You can do it yourself or hire someone, and they'll go through patents and say, hey, this isn't out there, or this is out there, or it's really close to something that's out there from a patent. Because again, it's the right to stop. So just because you don't see it on the market doesn't mean something doesn't have a patent. And that runs into non-infringement. So if I come up with an idea, a product, a thing, I don't know if someone has a patent or is making it. I don't want to get sued. So I might have a non-infringement search conducted to make sure what I'm doing is okay. Let's assume everything's okay. Timing. I have to file for a patent within a year of my first public use or disclosure. And the sooner the better, because if I show it and someone sees it and copies it, well, that could really mess things up for me. So the typical advice here is to file before you've publicly disclosed it, but sometimes that can't happen. Outside the US, you have to file before public disclosure. So the US gives you a little grace period. Outside the US, there's no grace period. So you can maybe only file in the US. One thing you can do, it's called a provisional patent application. So this is a placeholder. This is an application that says, hey, I have a filing date of today. I have 1 year to write a full application, but I want the government to know I filed for this patent today so that I could go disclose it and rely on my date today as my filing date, even though the provisional patent application never becomes a patent. It's never examined. All they do is take your money and send you a receipt that says you filed something. Here's your number. So if a lot of times if a client calls and they say, hey, I have a trade show today, I'm going to show this thing, I'll take whatever they're going to show, file it as a provisional patent application, and then I have a filing date of today. So there are two main types of patents. There are also patents for plants we're not going to talk about, but those are actually the prettiest patents that are out there. But the two are utility and design patents. So utility patents cover the useful aspects of an invention, right? The functional features of a machine or a process or a manufactured item or something. So that's the useful things. Design patent, it's how it looks. So it's the configuration or shape of an article or what a product looks like. So that sounds a lot like the trade dress stuff we talked about earlier, because it is. It's very similar to trade dress. So it's often used in conjunction with trade dress because if you recall, design patents don't last as long as trade dress. So there's different rights and different legal remedies. So if you have one, you might want to consider the other. So this is a typical utility patent. I just kind of wanted to give you an example, what it looks like. So you have kind of the front page has some bibliographic information, the inventor, the assignee or company that owned it at the time it was granted, some other information. There's images, there'll be an image, a couple pages of pictures, and then columns of text at the end. This one is actually kind of a silly story. I think it was a patent attorney who wanted to show how easy it could be to get a patent sometimes. So he filed for a patent on a method of swinging on a swing, which was funny until the patent office found out that they did this. And so the patent office actually revoked this patent. So no one is going to infringe this when they go to the playground later today. So yeah, and I think he actually might have got in trouble for it. So, but this is an example of a utility patent, what it looks like. Design patent looks very similar, but because it's protecting an image or what something looks like, it's mostly images. So it has the bibliographic information, and actually then just this little text on the first page is all the text that's typically there. And it's mostly pictures to show what is protected. I'm happy to say that this design patent is expired, so you could make this pig grill if you wanted without infringing this design patent. However, if they created this, they may have a copyright for the sculptural aspects of the pig, so we may run into copyright issues. So you may want to investigate that if you're interested in making this grill. Here's another design patent that looks awfully familiar to some trade dress registration we saw earlier. So this is the design patent. And actually, it's hard to see on this, but it's not the outside. It's actually this inside that's covered. It's the solid lines, not the dotted lines. But anyways, this is a design patent that Apple got on the same thing they have a trade dress registration for. So these companies take the time to protect their IP assets in many ways. And so that the teaching point here is, small companies should do that as well. So what could be patented? Well, potentially anything that's man-made under the sun. Again, made here is included. So if AI starts inventing things, is AI going to be inventor in the US? No, currently. Outside the US, I think they may be treating it differently. So maybe in a year, I'll have to update this again. But what a product, an item, a device, a thing, any tangible thing, if it's new, processes as well. A method of doing something, a method of using an existing product in a new way is patentable. People used to try and patent business methods for a while. About 10 years ago, the legal system, the Congress kind of picked up on this, and they didn't like that. They didn't think that was fair. So they kind of carved this out, and it made it pretty hard to do this and made ways to challenge these. So a way of doing business written that way is probably not going to be patentable. And computer software in the US, unfortunately, is also kind of an uphill battle. There's some case law out there that's impacted us. And so computer software, which is a process, it's a thing, it's all this stuff, can be difficult to get a patent on, but not impossible. So if you're out there creating software, know that it's hard, and you really have to show some novelty, which means newness to the software. So what happens if you come up with something, notice an infringement? So typically most people put patent pending or design patent number and utility patent number on products so that hey, this is patented. Look at my cup, and maybe there's some patent numbers on the bottom. And you actually have to do that so that you can get damages. Otherwise, there's a limit on damages. But you infringe a patent if you make, use, sell, offer for sale, or import the invention without permission. Do you have to know about the patent? No. So if you don't know, it doesn't matter if you know or not. So like I said earlier, if I come up with something, you may want to do a search to see if I can sell this without running into any patent issues. Because if I do, we're back to some serious remedies. And what are those? Well, money damages. I have to pay some money for my fees, which could be tripled. If I knew about a patent and said, nuts to them, I'm going to do it anyways, they could triple the damages. So if it went from $1,000 to $3,000, that's not so fun. So, if you know of a patent, that's not a good plan. Again, attorney's fees. So this is another statute out there that kind of flips it and gives the patentee, or actually sometimes the loser, but the alleged infringer, the right to get the loser to pay. Sometimes. And you get an injunction, a court telling somebody to do something or stop doing something. So that's very helpful. So who's going to own a patent for an invention? Well, it could be the inventor or the employer. An inventor might retain an ownership when the employee creates it. But if you're an employee and you're hired to invent things, the company is going to own it. But it does depend on where you live and what state you're operating in. So this is all determined by state law, even though patents are federal right. So you have to look at state laws and see what the states say. So typically it's the inventor, but most companies that hire people to invent have a statement in the agreement, that the employee agreement, that says anything you invent while you're working for me that has to do with what you're doing for me is owned by me. And then that means that employer's going to own it. I have this little caveat, the Illinois Employee Inventions Act. So again, state law. In Illinois, there's a state law that says if I've signed one of those things and then I go home to my garage and tinker on, let's say, my motorcycle, and it has nothing to do with what I'm doing in the day, and I come up with some new invention for my motorcycle, even though I have this agreement about all my inventions go to my employer, that invention had nothing to do with that. So I still get the rights to that invention. So that's a caveat that's out there. So if you're a tinkerer and inventing things and you've signed one of these agreements, know that your home inventions in the garage are going to be yours as long as they have nothing to do with what you do for your company. How do you get a patent? Well, again, you have to register. You have to get it registered and get it allowed, approved by the government. And there's no easy way to say that. It costs a lot of money and it takes a lot of time. And if you get one, the utility patents, at 3 times over the life of the patent, you have to pay to tell the government, I still want to keep this patent in force. You don't have to do that, but if you do want to keep it in force, you have to keep paying. Getting a patent doesn't actually mean you have to make a product or otherwise use the patent. In fact, if I get a patent for a drug, I can't sell that drug unless some other branch of the government tells me I can sell the drug. So just because I have a patent doesn't mean I have to use it or that I can. It also doesn't mean I have to have something ready for the market. If I have an idea in my head and I can explain that enough that I can write it on paper and include some drawings, that's good enough to file for a patent. So you don't have to have a working prototype or anything like that to get a patent. And protection for a patent is defined by the claims. At the end of the patent, there's a bunch of numbered paragraphs. They're written in a very confusing and awkward manner, but that's what is protected. So it doesn't, for a utility patent, it doesn't matter what the pictures show, it's what the claims say. Design patent, it's the other way, because the claim in a design patent says, I claim what's shown in the pictures. So if you run into a patent, read the patent, look at the claims at the end though, to make sure, you know, that they don't have a ton of limitations and it's very specific in there. That's what's going to define what's protected by the patent. So the process. So again, it's the Patent and Trademark Office, the part of the Department of Commerce. There's their website, then the patent side. Again, file in line or on paper. And I looked this up the other night and I don't know how, well, I do know, but the fees actually have gone down for a small entity for filing a utility application. Gone down a little, but the government fees to do this are about $650. That's online. If you're in paper, it's more. Typically, what an attorney like I might charge for preparing an application is between $5,000 and $10,000. You don't have to have an attorney, but it is, again, this is an expensive process, whether you have an attorney or not. You don't have to do a search beforehand, but in view of the fees, most people typically do. You could go to the patent office to search. You can go to the Google website at this link to use this to search. It's what I search with, so I would suggest starting there. The process, you spend all this money, you've done all this work, and nothing happens for like 2 years. And typically the first thing that happens is them saying, no, you don't get a patent. So you have to go back and forth. So spend all this money, you wait, and then you have to spend some more money and wait some more time. So it's a process. But in the end, you know, when you get a patent, it can be very, very helpful. I mentioned this provisional patent application, so that's a very small filing fee. It doesn't have to be a formal application. You want to have as much as possible, but you don't have to. So you file that filing fee is really little, $120, and you have a year. A design patent, again, it's smaller fee. Again, it's based on the drawing, so the amount of work involved is lower. And so that's an easier, lower cost application than a utility. But again, this is only going to protect what something looks like. So I kind of reached the end of my slides here. And I know people have been typing along and adding questions. I think there's a Q&A and then there is a chat. So I'm going to open the Q&A first, but if you have any questions right now, you can put them in the chat and I'll look at the chat then in a second. So I have the chat open and the first question we have is, can a book be copyrighted even though there are references from other works or images that are public? And absolutely yes. So just because my book has a photograph that's somebody else's in it, it doesn't mean that I don't get a copyright in my book. You know, you will get a copyright in what you've added in that book, but you don't get a copyright in the image that you took to put in your book. So you can use publicly available things in your books and on your websites and stuff like that, but you're not going to get copyrights to those things. You're only going to get protection in the original stuff you've created. Can you get a presentation link? I think they emailed this out, but if my email's on here, if you send me an email, I will send it back to you and you can have a copy of this PowerPoint to read at your leisure when you're tired and can't fall asleep. I have a question here. I have a slogan and a logo design, so I need a patent, copyright, trademark, or all three. So We'll do the easy one first, right? The logo. If you've created that logo, whether or not you're selling any goods, you come up with a new picture, an image, that's a copyright. When you slap that picture on goods and services and start using it, that's a trademark. When you use your slogan, which is a saying, that's probably going to be a trademark. I suppose if you had a slogan that was a limerick, that was kind of a poem or something like that, you may also have a copyright in that slogan written that way. But generally speaking, a slogan is going to be treated as a trademark. So once you put that slogan, use that in association with goods and services, then you've created trademark rights. But until you do that, remember, you have no rights yet. So you gotta use it. So if you're creating a new word that you're going to use on a name for a product, should you work on getting this trademark federal? So first, the trademark, you don't have to file, but if it's a word you've completely made up, you may want to file so that no one comes in and swoops in. Before you start using it. Because if you come up with a word and you take your time to get your business going, which is totally fine and totally happens all the time, but you've based your whole business on this term and someone comes out and uses that term before you, they're going to beat you to the rights. So you may want to consider filing an intent to use application, which is, hey, I want this date as the date I can show the world that I was going to use this mark. And if someone starts using it after that date, even if you haven't used it first, you're going to be protected. So, if you're starting this path, you may want to consider that. And now you have a unique recipe for a coffee-based drink. That would be, certainly something that could be a trade secret if you don't tell anyone. People that come up with recipes often ask about this. Can I file for a patent for the recipe? So the trade-off here is if you do that, you have to tell everyone what's in your recipe. So if I keep it a secret, as long as it's secret, I can protect it. If I file for a patent, I have to tell everyone. Once my patent runs out, then anyone can copy it. So it's a business decision you have to make along the way. I like this chemistry question. I was a chemist. Can someone register a molecule or its depiction as a trademark or copyright? So I in theory, I don't know, you could use an image of a water molecule. I guess if you were using that and it was water, maybe you would have an issue with that. I don't know that you could get a copyright for it. If it was a unique way of showing that molecule, and water is a really bad example because it's a simple molecule. But if you came up with a cool design drawing for water, you have a copyright in that design. And if you were using a molecule image as a mark for goods and services, there's no reason that couldn't potentially be a trademark. So you could do both. All right, if you hire someone to develop a web app, how do you prevent them from copying the design? Well, again, that goes to, I'm hiring someone for my business. And what was my lesson here? Have it in writing with the money you're giving them that says, anything you create for me, I own. And you agree not to use that for anything else. You don't need a lawyer to write the contracts like that. Just make sure it's clear and make sure, when money's changing hands, you know exactly what people are doing. And if they're creating stuff for you, make sure you get the rights to those things. On the flip side, if you're creating stuff for other people, maybe you want to make sure you ask a little more money if they want the rights in those things. So, all right, can the content and physical form of a book serve as a standalone trademark if mentioned copyright at the beginning of the book? All right, so we're kind of flipping two things here. The content of a book would be a copyright. So if I wrote a book, it's copyrighted. I don't have a trademark in the book. The form of a book, I don't know what you mean, but how it looks, maybe if you were selling books with a unique color design on the spines and something like that, some way that was unique, that could potentially be a trademark. So you have to remember the different things that are being protected and the different ways you use them and what they protect, right? A comic book character Do I need to trademark the name of the character or copyright the design of the character? Well, I think, again, you've got multiple things here. The name of the character would probably be a trademark, right? Because that's a name and it's associated with entertainment in the form of comic books. The design, the way the character looks, that would be at least a copyright, but maybe also a trademark, right? Maybe on the cover of the comic book, you have just the headshot of, Venom with his tongue out and his fangs going or something like that. That little logo could also be a trademark in addition to being copyright. So, these two, trademark and copyright, when you're creating things that could do both, can protect both. Should I file for a provisional trademark for slogan and logo I'll use on t-shirts? So there's provisional is patents. So trademark is something else. And logos and slogans on t-shirts, the trademark office is really wanting to see those on the labels associated with the t-shirt, not just Smith's legal services on a t-shirt. They've really kind of changed their view here and have kind of cracked down a bit. So if you're just going to put it on the front here, which you can't see my chest, but on the front here, you probably won't be able to get a trademark for that. So you got to make sure, in addition to putting it on the front, you're slapping stickers on the sleeves every time you sell it, or the labels on the sleeves have the logo on it. That would be my thought on that. I know it says we have a minute. I'm going to jump to the webinar chat and try and answer some of the questions in there as well. And I can wait a second and be a couple minutes late to my next meeting. It's okay. I hope the echo ended. I'm sorry. I do work right next to the L. So sometimes that affects it. As an educator, if you have your logo trademark in the state of Illinois, is it necessary to file with the federal government? The protections between state trademarks and federal trademarks are different. So necessary, no. It's never necessary to file a trademark. Would it be beneficial? Probably. That may be something you want to do because that's going to protect you outside of Illinois, right? An Illinois mark might only protect you in Illinois, but we're close to a lot of our neighbor states. And so if you work in Illinois, probably deal with Indiana and Wisconsin and Michigan. So you may want to think about expanding. What's the worst case scenario for filing provisional patent for service? I guess I don't know what worst case scenario here is, but if you come up with a new service, I don't know that you want a provisional patent application. You could file that. If you file a provisional patent application and then you go, you know what, this isn't worth it, or you talk to a patent attorney and they say, I don't think you're gonna get a patent, nothing happens. In a year, the provisional patent application disappears like it was never filed. It's secret at the patent office. Unless you go and show someone you filed, no one's ever going to know you filed it. So if you file a provisional patent application and then decide to do nothing with it, I guess that's the worst case scenario. And the worst thing that would happen is you spend some money that didn't go anywhere. I think I answered the web designers before. Again, get it in writing, especially when you're dealing with money changing hands. A clothing brand, should I trademark or copyright the logo? So at this point, when I was a teacher, I'd ask the students, I'd be like, what do we think? But so if it's a name, it's a trademark. If you created a logo that's new and then you could copyright that as well. And as long as you're using it on the goods, trademark that. Do I need a patent? Unless your clothing is new, something new about the clothing, you've created a new fabric or new stitch or a new way to make it. I would say there's probably no patent involved here. But if I'm wrong and there is a new stitch or way to make it, then maybe there is a patent involved. Just jumped because someone typed something. But most of the time, that's going to be copyrights and trademarks. You're welcome for all the information. What is the most typical R class 4 magazine? Albert, I don't know, I'm sorry. You can go to the website that I said, the trademark office website, and you can search by class. I don't have the classes memorized because I don't have the classes memorized, but you can go in and type what your goods and services are, and it'll tell you what class. You can also file without specifying a class. At least you used to. I'm pretty sure you still can. And the trademark office will look at the goods you pick and tell you what class. So if you're going to file on your own, you don't have to put a class. You can just rely on the trademark office to pick it for you. Did you hear me say that if you find a new way to use an existing product, you can possibly get a patent on the new way of functionality? Yes. So the patent statute actually says a new way of using an old product. And I often have to remind the patent examiners at the patent office about this as well, because a lot of times in my dealings with them, they like to cite a picture of the existing product and say, hey, the product is known, therefore the process is known. And I have to say, no, actually, if I come up with a new way of using it, I can get a patent. So that is possible. Again, that's only going to protect the new way of using it. So it doesn't mean you can stop people from selling the old thing. It just gives you the right to stop people from using it in the new way. Again, if they don't have this available as a slide or PDF, feel free to send me an email. My email's at the I think in the chat or on the sign up you had. If not, it's a really easy name to search, Pat Smith, GBC. And that, let me see, I think it's on the next page maybe. Yeah, but that's my picture. But my email's down there. So feel free to send me an email and I'll send it to you for you to peruse. Thank you all for the nice words and thanks in the chat. It was my pleasure. I think that was all the chat. I'm gonna jump back in the Q&A. How do you apply for a name trademark? So in the website or in the presentation is a link to the website at the trademark office where you could file. And if you're have a company that's going to be the one doing all the work, make sure the company is the applicant. But you know, it is a fairly straightforward application of, you know, what's the mark? Do you have an example? Who's going to own it? And if it's the company that's going to own it, put the company name. If it's you as an individual, put you as an individual. If you have a unique way of processing data and algorithm, what's the best way to do that? My current thinking on that would be a trade secret. Keep it a trade secret. It is difficult to get patents on software right now, unfortunately. And even it's hard. And the amount of time it's going to take to get a patent is going to be long. And a lot of times technology moves faster than the patent office. So by the time we'd ultimately even get a patent, it could be 5 years from now. And is that still going to be something that, you know, we want to look at? So unfortunately, I don't like saying that, but that might be the way I think. I could be wrong. You know, every situation is different and facts are always important, but that's currently where I think my position would be on that. I'm looking at my big face, so I'm going to stop sharing. And unless anyone had anything else to say, I think that's about it.
Thank you, Patrick, for today's presentation. I hope all of our attendees got the information that they were looking for. If you are a part of the BACP Entrepreneur Certificate Program, your digital webinar card will automatically be updated within 24 hours. In order to earn a certificate, you must enroll in the program itself. And you can do that by visiting chicago.gov/BACP certificate. Registering for webinars does not automatically enroll you in the program. Thank you again for today's presentation, Patrick, and I hope everyone else continues to have a great weekend.